judge, if they're sitting there, has some avenue that they could use. They could hold the prosecutor in contempt of court, which they don't do very often, but should be done more often, in my opinion. If you're a judge, a trial court judge, and you're sitting there and you see gross prosecutorial misconduct going on in your courtroom, that prosecutor is in contempt of court. And he should be held in contempt of court. You conduct a hearing, hold him in contempt of court. Put a stop it. You've got to let the prosecutors know that you mean business and they're not going to get away with it. If you just admonish them and do nothing about it, you'll accomplish nothing. Because they'll continue to try to get away with anything they can get away with. That's just human nature. And again, I'm not impugning prosecutors generally. I'm just saying that there are some that are improper prosecutors or bad, what I call bad prosecutors. But that's a limited number. Those are whatever I'm saying is directed only to that limited number of prosecutors, because we have wonderful prosecutors out there that conduct themselves the way they should. So I'm not impugning all the prosecutors. But there's just too many that shouldn't be prosecutors. Unfortunately.
And I just have a couple more questions. What reforms do you believe are necessary to help prevent wrongful convictions?
What was that again?
What reforms do you believe are necessary to help prevent wrongful convictions?
Well, we've been talking about some of these things. Where there's serious prosecutorial misconduct, the case has to be reversed. And not relying on this harmless error business. I never really liked using harmless error too much, because the error is harmless only if you are not the victim of it. And you never know what's harmless or harmful in the trial of a case. And because the Supreme Court, U.S. Supreme Court, I'll give you an example. U.S. Supreme Court, and it is the law. The U.S. Supreme Court said that even constitutional violations can be harmless error. That's the law.
Right.
I would never agree with that personally. I would follow that as a judge because the U.S. Supreme Court says that's the law. But in my opinion, if a right is so important that they put it in the Constitution, how could you say a violation of that right is harmless? Makes no sense to me. So if I see harmless error, and then I see an opinion where the court says, if I see a constitutional violation, and then I see the opinion say, well, it was harmless error, to me that makes no sense whatsoever. I'm saying that is the law because the U.S. Supreme Court says it is the law, and the Illinois Supreme Court says it's the law also. It's nonsense, I feel, personally, okay? For the reasons that I said, if it's a right that is so important that they put it in the Constitution, and then it's violated, I don't think you could say it's harmless. That's my opinion. So, it's just the way I feel. And if I was the ultimate judge, I would reverse that doctrine that says that constitutional errors, constitutional violations could be harmless errors. That makes no sense to me.
And I just have one last question for you. What advice would you give to innocence projects?
What is it?
What advice would you give to innocence projects?
Keep up the good work. they do that. I mean, they're doing something that is very good, and the public needs needs agencies like that.
Mm-hmm.
Because as an example, are you familiar with the what's the police officer that was
Birch? John Birch?
John Birch.
Mm-hmm.
Yeah. I wrote the opinion in the first case
Mm-hmm.
in Illinois involving police torture where the case was reversed. The John Birch incidents,
Mm-hmm.
in effect, started with the case that I had called People versus Banks. In People versus Banks, the defendant was convicted, and I reversed the conviction.
Mm-hmm.
The accused said that, and this was Birch and his group that was involved,
Mm-hmm.
they had put a plastic bag over his head, they put a gun in his mouth and started pulling the trigger. All kinds of torture
Yeah.
to get a confession from him. And the defendant's lawyer tried to put that evidence in during the trial.
Mm-hmm.
And the defendant's lawyer had another person that was accused and convicted prior to that,
Yeah.
where he testified, where he said that these same police officers, the John Birch group,
Mm-hmm.
did the exact same thing to him. So it was clear it was a pattern.
Right.
So the trial judge in the case believed the police officer
Mm-hmm.
and would not allow the jury to hear any testimony about police torture to obtain this confession.
Yeah.
Incidentally, the trial judge in that case was a friend of mine.
Mm-hmm.
I reversed him anyway. But the case came up before me, and I read the record, and it was clear in this record,
Mm-hmm.
in my opinion, that this was a pattern of police torture. Up until I wrote this case and reversed it, and in the opinion, I get into this business about police torture
Yeah.
and all of that. It's a very important opinion, I think. It's called People versus Banks.
Mm-hmm.
And I described what the trial judge is, and I said in there that trial judges have a responsibility
Mm-hmm.
to make sure that when they see something like this happen, they've got to conduct a hearing and you got to stop it.
Mm-hmm.
And so I reversed the conviction, and I said some stuff in there that got a lot of attention,
Mm-hmm.
public attention.
Yeah.
And it was the first case in Illinois that exposed police torturing of any kind and the conviction was reversed.
Mm-hmm.
Okay. It was the first case in Illinois, in the history of Illinois.
Mm-hmm.
So after the case came out, the case got a lot of write-ups and stuff like that. And then in a short period of time, there was another case, and they started seeing that there was a pattern,
Mm-hmm.
and it was the Birch group. And
Right.
And then all of a sudden it became investigated, and that started the Birch scandal.
Mm-hmm.
So that was an important case. And it's very interesting, the state of Illinois, the superintendent of police, and the state's attorney's office
Mm-hmm.
should be ashamed of themselves as a result of the Birch thing. in that he was never indicted criminally. They knew what was going on. There's no question that they knew what was going on because the superintendent of police sent a letter to the state's attorney. The state's attorney was Richard M. Daley at the time. Breezak, I don't know how he spells his name, I think was the superintendent of police. He sent a letter to the state's attorney saying that it looks like there's a pattern here of torture. What do you want me to do about it? And you want to know what they did about it? Nothing. So then they conduct, years later after the scandal breaks, they conduct an investigation. They appoint some special committee to investigate. So they conduct this investigation and they prepare an investigator's report of what they found. And they found, well, there was evidence some of these convictions were based on torture and stuff. There was some torturing, but there was nothing sufficient to indict anybody. And the statute of limitations had run on most of the cases, they said, so nobody was indicted. So the statute of limitation ran, and Burge was never criminally indicted, ever, to this day, for torturing people to get a confession. And a number of those people were sentenced to death. And then the U.S. attorney, there was a civil suit filed against Burge. And in the civil suit, he lied under oath at his deposition. And the U.S. attorney indicted him for perjury in a civil trial, not a criminal trial.
Yeah.
So that's what he was convicted of. Never criminally for the torturing.
Yeah.
He was convicted of perjury in a civil trial. And to let that man get away with that is a black mark upon the state's attorney's office in the city of Chicago. Because it's no question, in my opinion, that they knew what was going on. And he's only sentenced to 4 years in prison. He's ready to get out of prison, Burge. So he will never be criminally indicted for these crimes that he committed. It would cause people to be sentenced to death penalty. And some of them are still in prison. And they're trying to get their cases heard. Because their confessions were obtained by torture from Burge. And they can't get their cases heard. They're still in prison.
Right.
They're trying to get their cases heard, and they've taken some procedures. In my opinion, the procedures that they've taken are inadequate because these people are still languishing in prison while they're trying to figure out how they can process their cases. And in my opinion, they should call them all up, get judges to hear them, and find out if there was torture, and instead of trying to worry about some system developing, which is what they're trying to do now. And meanwhile, they've got people who probably or maybe innocent languishing in prison for crimes they didn't commit. It's nuts.
Yeah.
It's terrible. That's my opinion. What else you want to ask me?
I don't have any other questions. Do you have anything?
No.
Okay. I think we're done here.
That's it.
Thank you so much.
Thank you.